Hello, everyone. How is everyone today? Hello, Rosie. Hey, can you guys hear me? Let me know if you guys can hear me, please. Hello, Raging Night Wolf. How are you today? Hello, Rudy. Okay, so you guys can hear me okay? Okay. Hello, Erica. Okay, so I'm going to jump right into this, you guys. Anybody that's coming in afterwards, I guess, can catch up. I'm great, Raging Wolf. Thank you for asking. I'm great, Titan. Raging Wolf. Thank you for asking. Okay, so I'm going to get into this. I just want to get all this over. I checked the court docket this morning. Okay, so and checked I'm going to get into this. I just want to get this is just all this over. I checked the court docket this morning. Okay, so the defense I'm going to get into this. Mainly, this is just all this over. I've been doing all this court docket this morning. Okay, motion to stand trial and trying to have Rob Wood on the case. It seems now Rob Wood has jumped on the bandwagon. This is the way we have Rob Wood. That's how we're going to be. So this is turning now Rob Wood has jumped on the bandwagon. This is the way we have Rob Wood. That's how we're going to be. Was filed. So this was filed back on the 24th, where Rob Wood was asking for a motion to compel, where and this was because Marquise and John Pryor had not turned over and this was because disclosure. Now that disclosure was John Pryor expert witnesses, turned over, etc. And this was regarding this is that disclosure was this right now, you guys, is just turned over the hearing that is coming regarding just calendar here. This right now, you guys, is just the hearing that is coming regarding Okay, so this is all in regards to the hearing that is coming up on Monday, March 22nd. Okay, and that is where the defense has filed to dismiss all the charges and to change the venue. Monday, March 22nd. So all these motions now are just to deal with that. It's not even for the trial yet, and it's just getting crazy. So all these motions now are just, like I said, with the defense trying to have Rob Wood thrown off the case and everything else. It's just gone crazy since then. Like I said, there's a bad echo. Trying to have Rob Wood thrown off the case and everything else. It's just gone crazy since then. Like I said, I'm not going to share the audio, and hopefully that works. Okay, you guys, let me know if that works now without the echo. Okay, is it better now? If not, I'll just throw my headphones in. Is the echo still there, you guys? Everything's good now? There's no more echo? Okay, so the echo is gone. Please just let me know that the echo is gone. Can hear you fine now, Willow. Okay, thank you. Okay, so like I was saying, with the defense, what they did, trying to get Rob Wood thrown off this case and everything else, and all the debacle there that happened, this is now getting out of hand because Rob Wood, now they've just peed him off. I don't want to say the word I want to, but have really got his goat. So now everything is going to be by the book by him. Okay, so I guess Rob Wood, who is the special prosecutor, had asked Mark Means for expert witness names and exhibits that they want to use in this upcoming hearing on March 22nd, where the defense wants to just have all charges dismissed, and if they're not dismissed, they want to change venue, which means they want to move the case out of Fremont and move it somewhere else, like counties over. So Rob Wood says, well, if you have all these experts, because Mark Means had said that they did some kind of survey, whatever, and we're going to get into that. So Mark Means, so Rob Wood filed this on the 24th of February saying, okay, if this is what you guys say that you're going to do, I want disclosure on everything. And he filed for a motion to compel. So this is that motion, and it is supposed to be held on the 10th of March. Now, what's happened since then has just gone haywire. Okay, so I guess Mark Means and John Pryor did not give a disclosure. In some of the responses, John Pryor just did not give a response, and in his response just put none, which means I'm not responding to that. So this is the hearing on that, which is the 10th of March, because now Woods just wants them to hand over everything. But now there is another hearing that is scheduled for the 8th because things have just gone haywire. So there's a motion to compel already set for the 10th, and now there is another motion to compel hearing set for the 8th, and this is why. So Mark Means replied to his part of this motion to compel that Rob Wood filed. He says, okay, if you're going to use this for the change of venue hearing, we want the person's name who did this survey. We want all his credentials. We want a copy of his findings. Mark Means did not file that to him in time, so now he started another motion to compel. So there's 2 motions to compel that are outstanding. One is going to be heard on Monday. The second one, where John Pryor replied in his response, none. That's going to be on the 10th. So this one that's on the 8th is due to this. Mark Means responded. Okay, motion to allow virtual appearance of expert witness Ironwood's insight. Okay, so apparently what happened is Mark Means sent a bunch of stuff over to the prosecution, and the prosecution went through it, and they are not happy. Okay, so which means they have another motion to compel, and a motion to expel witnesses that the defense wants to have. We're going to get into it. It's all here. So this is what Mark Means has filed. He said he didn't want to give, the person that did the survey didn't want to give his name for obvious reasons, only under seal in private where nobody else can hear it. Why? I have no idea. If you're going to do a survey and you're going to conduct a survey and you want to be known as in court as an expert witness, and you want all your findings to be under the expert witness protection and be taken as expert testimony, then you best be giving your name, giving copies and everything, full disclosure to the prosecution. So now Mark Means filed this saying that he wants a motion to allow virtual appearance of expert witness, and this is the company Ironwood Insights that did the survey. Okay, so he says, hereby comes defendant Lori Noreen Vallow by and through her attorney of record, Mark Means, and move this court to allow expert witness Mr. David Bryant of Ironwood Insights to appear at the motion to transfer, which is they want to change the venue, by Zoom. So he doesn't want to have to pay to bring this witness into the court and to, you know, pay his motel and everything else and travel and his time and everything. He wants to be able to him just come on the Zoom meeting. So I don't think that the judge will deny this. He does give his name now, which he did not want to do. So this witness, expert witness, is Mr. David Bryant of Ironwood Insights, and he wants him to be able to appear by Zoom. So he doesn't have to bring him. He says it's too far or whatever. Okay, it says he lives in the St. George, Utah area, and the cost to have him appear in person is tremendously outweighed by the benefit of appearing virtually. No party can credibly claim prejudice by his appearance virtually at this motion. So I believe the judge will grant that. But this is where it gets funny. Okay, so this is just a certificate of service. So once Mark Means filed this, he also filed this. This is a supplemental expert witness disclosure. Okay, so what the prosecution was asking for, they've now, and was denied. The defense didn't want to give it to him, but now they've given his name. They've given his credentials, which we're going to see here. but they still will not give the actual survey. They still haven't given him that. So then he filed another motion to compel. So this is what Mark Means did give. Okay, so again, it says now the defendant, Lori Noreen Vallow, by and through her attorney, Mark Means, provide notice her expert witness disclosure as follows. Ironwood Insights, the attached curriculum, his resume, contact information, expert information, expertise, contact information, credits, awards, publications, etc. But nothing in there states that he is giving the actual outcome and findings of this survey, which is one of the things that Rob Wood wanted and requested in disclosure. You have to disclose that. So I've gone through this, and what I find funny about this is this guy's resume. Okay, so this just states that Ironwood Insights has been retained by the above defendant and is expected to testify and offer factual and expert opinion in accordance with the relevant statutes, laws, findings, recommendations, blah, 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 regarding all aspects of this case and specifics into scientific survey results. But he doesn't include the results, which is one of the things he has to include in disclosure. He's still not including that, and that's what the prosecution wants to see. He wants his name, he wants to know where he works, he wants to know his credentials, and he wants this survey. So this, if you want to read through all this, you can go ahead and pause it and read through it. Hello, everybody that's coming in. Hello, Darlene. Hello, Missy. Okay, so he says they will offer reasonable inferences, opinions, scientific survey results, an expert report, findings, or the like incorporated herein by reference. Their testimony will include the nature and extent of errors, omissions, malpractice, misstatements, incorrect assumptions, unfounded opinions, etc. Okay, well, where is the paperwork on that you have to file, Mr. Means? You can't just say it, you have to file it if you intend to use it. Okay? So like I said, if you want to read through all this, go ahead, but this is what he filed. Okay? So what he filed was, that's just a certificate of service. This is the guy who did the survey that says they cannot get a fair trial in Fremont. They've got to have a change of venue. So this is what Mark Means is going to rely on. So this is this guy's work history, okay? His credentials, whatever you want to call it. This is all Mark Means gave him. He did not give him a copy of the survey that was done, how it was done, who was part of that, whatever. This is what he gave him. Just like you're going to do a job application, you know what I mean? And what I find funny about this guy, you guys, this David A. Bryant that apparently works for Ironwood's Insights. He's the one that apparently did this survey that says there's all kinds of reasons why they can't get a fair trial. Look at his resume. Okay? October 18th to present, he works for Ironwood. May 18th to September, only for months, he worked for Economic as vice president of Economic Systems, vice president of Ironwood Insights. Okay? January 18th to May, only a few months, vice president of Blackstone Group. How is he vice president of all these companies in such short time? And you will see this throughout his whole resume, okay? From December 12th to March 2017. So December 2012 to 2017, he's vice president of yet a different company, Thoroughbred Research Group. Okay, so I'm just checking the comments on my other monitor, you guys, as I'm doing this. But look he's vice president of all these named companies. Okay, this is so far the longest he's been at one company. But these are just months: January, February, March, April, May, 5 months, 6 months. You're vice president of these companies in different states. Okay, it goes down here, what he did there. September 1st, September 2001 to December 2012, so not very long. Well, yeah. Okay, 11 years here. I don't get this. So for 11 years, he's senior vice president and director of health policy at this company. So February 2000 to September 2001, he's chief operating officer for this company. Okay, 97 to 2000, he's vice president of this company. You see what I mean, what I'm getting at? How is he president, vice president, chief operating of all these different companies in sometimes for only months? 94 to 97, president. 89 to 94, vice president, chief strategy officer. 85 to 89, director, forecast modeling, senior market research analyst. Okay, so this is, I guess, where he starts. But when you look up here, October 2018, so 2.5 years, he's vice president at Ironwood. From May 2018 to September 28, so only months, he's vice president for this company. And then here again, only for months, from January to May, he's vice president of this company. Like, how is he vice president of all these companies? This is like, I don't know about this. I don't know about this. But anyway, so then they go on. This is his resume. Then they go on to give his articles and papers that he has written, I guess. How are you doing compared to the competition? What is driving your patient's experience? So different articles or whatever he has published. I mean, I could publish things in papers too, you know, so that's really, that doesn't, I don't know. But related professional experience from October 95, while he's president of all these other companies, he's also doing this. He's also an instructor of economics and statistics research at the University of Phoenix. And this is all during while he's president or vice president of all these companies. From 83 to 90, he's associate professor, management of information system at the University of Business and Management in Pepperdine. And then from 80 to 81, he's an econometric consultant and programmer for Lemur. Okay. So this is all that Mark Means gave to the prosecution when the prosecution asked for disclosure on this survey. Okay. Okay, where's the survey? Mark Means didn't give it to him. So now you're making Rob Wood even madder. So not only this, Mark Means also, I don't have the paperwork because I don't see it filed, must have filed other paperwork with other people that other witnesses. There's no paperwork on it. So which means he did not file the paperwork, but maybe just verbally told Rob Wood that he also is going to call other people. Okay, so this is the motion now to compel. That's going to happen on the 8th. Okay, so this is what Rob Wood filed after Means filed this resume, but no other disclosure on the survey actually done. So Rob Wood files the motion, which will be heard on Monday, the 8th of March. State of Idaho, acting through the Madison County Prosecutor's Office as a special prosecutor, hereby moves the court for an order to compel the defendant, Lori Vallow Daybell, to comply with the state's specific request for discovery and provide any reports prepared by the defendant's expert witness, Ironwood, no later than March 12th, so that the state may have adequate time to review the said report and respond. Okay, so like he's saying, On February 16th, the defendant filed an expert witness disclosure listing Ironwood Insights, but did not provide any CV or witness names. On February 22nd, the state filed a specific request for discovery regarding Ironwoods. On March 1st, the defendant did disclose an expert witness name and CV, but did not disclose a report, as stated that the report will be produced to the state and Mr. Pryor upon receipt to Mr. Means. The state is filing this motion to compel to simply preserve its right to have sufficient time to review any expert reports and respond before the hearing on March 22nd. Okay, so this is what he's asking for. Now, something else. Mark Means must have said something to Rob Wood that is not in the court papers online. So, Rob Wood has filed another motion online, okay, which is for, this is also going to be probably heard on the 8th of March. The state of Idaho, acting through the Madison County Prosecutor's Office as a special prosecutor in the above captioned case, hereby moves this court for an order excluding the defendant's witness, Andrea Tracy Schatt, from testifying at the hearing on the defendant's motion to change venue about the results of her survey. So I guess they hired a few more people to do more surveys, and excluding the survey created by Mrs. Schatt on the following grounds. On 2 occasions, Ms. Schatt conducted an informal surveys of residents in Fremont, Madison, and Bonneville counties in regard to the above captioned case. The defendant has provided no CV or other evidence that Ms. Schatt has the knowledge, skill, training, or education to conduct an accurate and unbiased poll or survey and present those findings to the court as required by Idaho Rule of Evidence 702. Oh, he's not done. So yeah, so Mark Means has given them nothing regarding this person, Andrea Tracy Schatt, that he wants to call. Also, due to Mrs. Schatt's lack of knowledge, skill, training, or education, the informal survey she created was biased, irrelevant, and has no evidentiary value to the court. Further, the defendant has refused to provide the state with any materials upon which Ms. Schatt relied to perform her informal survey. Until March 1st, 2021, the defendant had refused to provide Ms. Schatt's name to the state, though it was previously requested in discovery on December 9th. Further, the state has requested the names of any expert witnesses the defense intended to call on August 17th. So he's had a lot of time to give the prosecution these names, and he's just doing it now because I don't know why. So on March 1st, the defendant declared in a response to discovery that Ms. Schatt was not an expert witness, but rather a lay witness, whose purpose at a hearing will be to lay foundation for the informal survey she conducted. What? Nothing in Idaho Rule of Evidence 701 allows an unqualified layperson to conduct a scientific study for which they have no qualifications, such as knowledge, skill, training, or education, and then present that study to the court. So that's just like Mark Means grabbing somebody off the street and saying, hey, go ask these people a bunch of questions, come back and tell me what they said, and I'm going to use you in court. Because he's given nothing to show any how this person is even qualified, let alone he just gave the prosecution her name. So he's asking that no, not allowed to use her. Okay. Having that Ms. Schatt perform an informal or non-scientific poll for which she was not qualified and then attempting to label her a lay witness is simply an attempt to circumvent the rules of evidence and present otherwise inadmissible evidence before the court. Exactly. Okay, and then his affidavit of service. Okay, so that is for this Andrea Tracy. But Mark Means was not done yet. Okay, he also tried to get somebody else in under the same kind of way. Okay, layman terms. Okay, so another motion for the same thing in the state of Idaho, acting through Madison County, hereby moves this court for an order excluding the defendant's witness Colombo Investigations, Joe Adraini, from testifying at the hearing on the defendant's motion to change venue about the results of his survey and excluding the survey created by Mr. Adrini on the following grounds. So this is the second one. On December 21st, 2020 and December 22nd, 2020, Mr. Adrini conducted surveys of residents in Fremont, Madison, and Bonneville counties in regards to the above captioned case. On March 1st, 2021, the defendant disclosed Mr. Adrini as a witness and provided a survey conducted by Mr. Adrini. Mr. Adrini was not designated as an expert in the defendant's disclosure. The defendant provided Mr. Adrini's CV. However, while Mr. Adrini's CV lists extensive law enforcement experience, nothing in Mr. I'm just going to say in his listed training or expertise established that he has the knowledge, skill, training, or education to conduct an accurate and unbiased poll or survey and present these findings to the court as required by Idaho Rule of Evidence 702. The survey conducted by Mr. what's his name is deficient and irrelevant, and it limits its questioning to simply ask respondents if they are familiar with the defendants and whether they are guilty or not. Okay, no questions were asked about whether a respondent could set aside their opinions and biases. No questions were asked about whether respondents believed in the principle of innocence until proven guilty. No questions were asked about whether the respondents believed the accused are entitled to a fair trial. The failure to disclose Mr. Adrini as an expert and the fact that nothing in his CV establishes that he has the knowledge, skill, training, or education to conduct an accurate and unbiased survey establishes that Mr. Adrini can, at most, be a lay witness in regards to survey or poll. Nothing in Idaho Rule of Evidence 701 allows a lay witness to conduct polling or surveys and present that evidence to the court. Mr. Adrini's testimony regarding the survey he performed and the survey itself should be excluded from the defendant's motion to change venue at the trial setting. And then it goes on to give his certificate of service. Okay, and then here is the next motion to compel hearing. So we have one back here for the 10th, for March 10th. And then we have this one here for the 8th. So I will be watching for both of them, you guys. If they are able to be streamed, I will stream the both of them. But we have two motions to compel now in the same week. And they're both coming from Mr. Wood. Like he sped up. Okay. So I'm going to get out of this. And now I got you guys back on screen there. Now I can see all your chats again. I do believe they do stream it. And unlike the Letitia one, I believe I can cover this. I'm allowed to stream it. As far as I know. Okay, so hello to everybody that's come in. Hello, Doug. Hello, Cat's Eye. Hello, Rosie. You were here. Yeah, so there's a lot of stuff there, you guys. There's a lot of stuff that most people just go, oh, yeah, okay, whatever. But when I see certain wording, like Rob Wood's out for blood. If the defense thinks that he is going to be cordial now, as they usually are, even though they are on opposite sides of the court, they're usually cordial with each other, okay? Especially when it comes to disclosure. Like, you can be in a lot of trouble for not disclosing stuff, or Your stuff, your evidence isn't going to come in unless you've disclosed it, and you've disclosed it properly. Okay, it needs to be into the record and filed with the courts in the record before certain dates. You also have to serve the other counsel, which is defense attorneys, prosecution. Everybody has to have copies by certain dates. It has to be filed with the court in the continuing record by certain dates. If those dates aren't met and you don't have a rock solid, like, you better have been, you know, all your staff and everything else in the hospital with something that you couldn't make it to file your documents, they're not getting in. You can't use them. Either way, candidly, I'll be able to hear it. So it's all going to depend. The first one, somebody said, couldn't see the date. Darlene, the first motion to compel is on March 8th. The second one is on March 10th. Sorry, you guys, I'm filling my face with raspberries as I'm talking to you. So there's two motions to compel brought on by Rob Wood, one on the 8th of March, one on the 10th of March, dealing with different things, but all dealing with the change of venue, which that hearing is on March 22nd, and the motion to dismiss, which both John Pryor and Mark Means want the charges dismissed against their clients. So the motions to dismiss and change of venue are on March 22nd. This is all just the junk leading up to that. Yeah, and it's just like, I get it. I get that Rob Wood is upset because they had tried to have him taken off the case and really disparaged his name, kind of, sort of, you know what I mean? So, like I said, even though defense and prosecution are on opposite sides, they're usually cordial with each other, especially when it comes to expert witnesses and disclosure. So why this blew up, I have my ideas as to why, and I believe that Mark Means was used as a puppet in a lot of this, being unfamiliar with how criminal trials work because he's not a criminal lawyer. And I believe John Pryor kind of used that to his advantage to get him to do things that, you know, it was just like, just throw that out there. Let's see how that works, you know? Darlene, the motion to compel on Monday is at 3:30 p.m. Idaho time, which would be 5:30 p.m. Eastern. The one on the 10th, the motion to compel, is at 9 a.m. Colorado time. 9 a.m. Idaho time, 11 a.m. Eastern. Yes, so you guys, we still have sitting in wait is Tammy's autopsy results that have not been released yet and won't be. And I believe a lot of the reason of that they don't want to release it yet is because they don't want the defense right now having that information. They want them to be wondering too what is in there. But because it has not been brought into this case, and it wouldn't be, that would be a separate case, they're not going to disclose anything about it right now. Hello, Cat H. The same as with if there's murder charges. I believe murder charges are sitting on the desk of the prosecution. And that is also being not spoken about because that will be a separate charge, separate court hearing. They don't want to bring it into this trial. Also, by doing that, there's a lot of things that are going to come out in this trial, you guys, that's happening with just these charges. With the bodies being found on Chad's property, with and Lori is also facing once this trial is done, she has another one starting too. She has 2 trials right now. And the other trial is still happening, and that is going to be, let me see. The end of, okay, wait, July. Okay. The charges on Lori alone for not producing the kids and going against the court orders and all that, that trial for her starts, her alone, July 12th. And I don't see anything being filed in that case, like, except for what's already there. So she has 2 trials that she's awaiting right now. She has the one with Chad. She also has the one where she failed to present the children and breached all those court orders and everything else. She still has that trial coming up too, and that one has been set for her alone on July 12th. Now, the trial for Lori and Chad together starts, the preliminary, no, I think they waived that. Let me just see here. Just going through my court thing here, you guys. Okay, they have to have all their exhibits and witness lists and everything in by June 28th for the trial. The pretrial for Lori and Chad starts on June 2nd. And their actual trial starts July 12th. And that runs for 3 weeks, just over 3 weeks. I'm just looking for, sorry, you guys, I made a mistake there. The trial for Lori's charges alone from when she failed to produce the kids and that doesn't start till August 30th, sorry. It's their joint trial that starts in July 12th. So after, and the July 12th trial, that's for Lori and Chad on finding the bodies on his property and whatnot, that is running 3 weeks. That runs from July 12th to the 30th. Could even run into the beginning of August, you guys, if they need the time. And Lori's pretrial for her charges alone start August 12th, and then her actual trial is scheduled to start the 30th. So the 12th and 30th of August are 2 more court dates she's going to have once she gets through this one. So that's where things stand, you guys. Also, Letitia Stout is back in court tomorrow in front of Judge Werner. I will not be trying to stream that because we are not allowed. So I will be sitting with my mouth zipped in the courtroom this time as to not get thrown out again. Hey, I've been working in the legal field for well over 25 years, and first time I ever get thrown out of a courtroom. And it has to be once I've retired, right? So my family has gotten quite the kick out of that. And virtually too. Can you imagine? So, and I believe that Letitia, you guys, is doing this all for clout. It's like, look at me, look at me, look at me. As narcissistic as they come. And the pain and suffering that she is going to impose on Lena, Al, Landon, and the rest of the family is just unbelievable, because she is going to be able to cross-examine them Darlene, thank you, Willow. June or July? What are you talking about, Darlene? What I've got, you should see my agenda. You're gonna have to tell me which one you're asking about. Yeah, Letitia is looking for clout. Wait, pre-trial for the both? What are you talking about? Oh, also, you guys, March 29th and 30th, Letitia's in court tomorrow. She's back in court for the proof evident presumption great hearing on the 11th of March. Then she is also back in court March 29th and 30th, and that is for her divorce. The 29th is going to be the status update. The 30th is going to be the permanent orders hearing, the final orders for her divorce. Yeah, and I'm almost, I don't want to jinx anybody, you guys, but I'm almost thinking too, like, does she think by representing herself that she's going to have like a spongy little office that she can sit in before court at the courthouse and, you know, stuff like that, where she could maybe try and escape? We don't know. We don't know what her motives are, but you can pretty much read her. Like, she says she has an ace in the hole. Well, she better be careful. I just went over with you guys about evidence, about stuff that you want to bring in. She has to disclose that. And that disclosure has to come in by a certain date. So if she thinks that she's going to go and sit in court and get halfway through this trial and then go, oh yeah, by the way, no, you got to disclose it. If you've got an ace in the hole, which she says, and I believe it's somebody that you are going to bring in to try and discredit somebody, or this is your proof that you did nothing wrong, like, oh my God. But anyway, this is my proof that I did nothing wrong. You got to disclose it all. It's got to be filed in the court record and given to the prosecution well in advance of your trial. Hello. So she thinks she's just going to pop up in the courtroom and blurt out this information. She's going to be shut up by the judge if it has not been disclosed. At that point, it's no longer an ace in the hole. She's not playing poker. Okay? If she's treating this court case like a poker hand, it's like, what are you thinking? You don't disclose nothing in poker. You keep a straight face, put some sunglasses on, put a mask on so nobody sees your facial expressions. How is she comparing this to playing poker? I got an ace in the hole. You got to know when to hold them, know when to fold them. Like, shut up, woman. Like, this is nothing compared to poker. In poker, you keep everything secret and quiet until you want to slam it down in front of somebody. In a criminal court, you got to give disclosure. So the comparison there, like, what is she thinking? Oh, Darlene, I don't believe so. I think she has a divorce attorney. And I don't know if family matters. I don't think family matters are open to anybody to just watch. Cat's eye. The thing with, I'm going to, how can she question someone under oath if you are married to them? Number one, they are legally separated. But even if they were still married, you can't be forced to testify against your spouse. That doesn't mean that you can't do it willingly, but you can't be forced to do it. But you can still do it willingly, even if you're married to them. But as I just stated, as of March 30th, long before her trial starts, they are going to be divorced. No, she's not very smart. And like I said, comparing what this ace in the hole she's got to a Kenny Rogers song. I don't know how many of you know that song, but you gotta know when to hold 'em, know when to hold 'em. The Gambler. It's called The Gambler. And it's like, yeah, you're gambling all right, because you're gonna look like an idiot. You're gonna look like that jackass. But no, she can't. If she thinks that she can just come out with this in the middle of the trial and say, here's my ace in the hole. No, you got to disclose things in a criminal trial. Rules of disclosure. She best be reading up on that one in the law library. Oh, Kenny Rogers? Yeah. The Gambler. Is that not what I said, Giovanni? Oh, I can't. I'm going to be cringing, you guys. And like I said, there's a lot of differences in courtroom procedure in the US and Canada. They're different. But it's going to be something to see. So is there anything else that you guys want to know about while I'm on here that maybe I can see if I can answer for you? Don't forget, you guys, Titan. Okay, makes a good point. Jurors are not stupid. No, they're not. And don't forget, she's going to be choosing her own jury because she's now her own lawyer. Does she know how to do that? I mean, even just choosing your jury, there's certain things you can and cannot ask. Like, I don't think she gets the scope of what she thinks she can do. I was in college and university for over 6 years learning what I learned. Like, I forgot. She's well educated. Ugh. Darlene says that means Al would not have to testify if they weren't married. No. What it means is somebody had asked, well, can she cross-examine her husband? You can do whatever you want. What being married and the courts, what the only thing there is, they cannot force you to testify against your spouse. But that doesn't mean you can't do it willingly. So there's a big misconception about that, you guys. And excuse me, Al is being called by the prosecution. I'm not sure about that. Lieber makes a good, I will be interested if the prosecution opts for the death penalty. I don't know if they're going to be doing that. I don't know if there's a death penalty still in Colorado. I don't have the link yet, Titan. But yeah, but anyway, it doesn't matter. Regardless, their divorce is going to be final the end of this month, long before her trial starts. And Al, Landon, Lena, family members are all being called as prosecution witnesses, which means Letitia gets to cross-examine them. I will do that when I get the link. I hate laundry. What time is Letitia's crap tomorrow? It's at 10:30 a.m. Eastern, 8:30 a.m. Colorado time. Yeah. Erica says she is still eligible for the death penalty. I don't know about that. I think Colorado did. Yeah, somebody just said it. Where is it? Yeah. See, Colorado did away with the death penalty. So if it hasn't already been presented as an option at a trial, which is usually in the closing, and when the judge addresses the jury and gives instruction, if that's not already on the table, which it's not because she hasn't even had her trial yet, then it wouldn't apply to her because they've done away with it. If Colorado's done away with the death penalty, the only ones that would be still subject to that, if they haven't abolished it totally, is any case that's already been instructed from the judge as that is an option. Okay. So she falls in the time list to have the death penalty. See, I don't know if even though she committed the crimes before it was abolished, I believe it already has to be on the table, which means when the judge instructs the jury, or when it's already been disclosed that that's what the prosecution is going for, is the death penalty, I don't believe it can be added now. But I don't know. I could be very wrong because the rules are so different in the US than in Canada when it comes. We don't have the death penalty at all here. So yes, I understand that, Erica, that the crime was committed before the law went into effect. But was it put on the table? Is it in writing from the prosecution that they intended to go for the death penalty? And was that put into writing before it was abolished? If it wasn't, I don't believe they can ask for it now. I think it had to have been asked for already before it was abolished. And I don't think they did that. Darlene, can I ask for a prayer for my son? Absolutely, Darlene, you can ask for a prayer for your son. We can all say a little prayer for your son, Darlene. No problem at all. I hate laundry says it would not surprise me that she asked for the death penalty. Yeah, see? That's the last I also heard, Erica, is that he hadn't asked for it yet. So I don't believe now that it's been abolished, I don't think he can ask for it because it's not an option now. He had to have asked for it before it was abolished is what I believe, but I could be wrong. I could be wrong, but that's my understanding of it. And like I said, we don't have the death penalty at all in Canada. So does she still qualify because she committed the murder while death penalty was an option? You would think yes, but if they've abolished it and the death penalty hadn't been asked for yet, I don't think they can now ask for something that's been abolished. But I could be wrong. Because the death penalty now is not an option. So unless the prosecution had asked for the death penalty as, you know, instead of jail, before it was abolished, then it would still be on the table. But I don't think he did. So I don't think that he can ask for something that's no longer available. So we don't know. Did he get his request for the death penalty in this case before it was abolished? If he did, then they could still have the death penalty on the table. But if they've waited until after it was abolished, Well, you can't ask for something that is no longer in the legal system as a punishment. Yeah. But like I said, you guys check into it because I could be wrong. But that's my understanding of it. As long as it was asked for as an option before it was abolished, I believe it's still on the table and still can be on the table as punishment. But if it wasn't asked for before it was abolished, you can't ask for something that's already been abolished, right? That's just my take on that. The last I heard, prosecutor said that it's still on the table. It can't be still on the table if it's been abolished, and he hasn't asked for it before it was abolished. So that would be something as a defense attorney I would ask for if the prosecutor now tries to see. I don't know. I shouldn't really talk about that because I don't know the law on it, because we've never had the death. Well, not that I know, that not in my lifetime has the death penalty ever been on the table. So I don't know how that would work. If it does apply because it was, the crime was committed before the law was, the option was abolished, or is it you have to ask for it before it's abolished? Once it's abolished, it's no longer an option, right? It's been abolished. So how can you ask for that option unless it's grandfathered because of the date of your crime? I don't know. I haven't really even looked into that. So maybe one of you guys can look into that for me. I hate laundry. You will see the option there to mute your mic and also turn your camera off. You have to turn off your camera and mute your mic. And what I thought I was doing, like, see, I'm on StreamYard right now, and I've got all these different things, like I showed you how I was sharing my screen. That's what I thought I was using when I was actually on the WebEx software. And on the WebEx software, I don't even know what buttons I hit to get to it, but apparently I requested streams of evidence. So there's got to be something. Don't touch anything. Just turn off your mic, mute your mic, turn off your camera. Don't touch anything else. There you go. Prayers for Devin. I wish him all the luck. And it sounds like he's going to go far, Darlene. So give him some congratulations for us too, for everything that he has already accomplished. And we will be saying prayers for him. So let us know, Darlene, if that gets published. Send us all a link. Send me the link and I will post it on my page. Domestic goddess. Well, as far as T's thinking, she's going to get off because she's such a great lawyer. Yeah. She got ace in the hole. She got ace in the hole that she's never going to be able to use. So, yeah, it's going to be interesting. And I think that there's going to be this trial. I believe they were setting aside a month and a half for the trial. They're going to have to double that because I can see a lot of objections from the prosecution. I can see a lot of the judge correcting her line of questioning. I can see her being dragged out of the courtroom because this is her way of her last dig at Landon and Al, her last chance to torment them. even more. Her last middle finger to them. So it's going to be interesting. And I'm having, now she has an assistant, a legal assistant that has been appointed to her. But that legal assistant can't represent her in court, nothing like that, unless she is pulled off as her own representation for good reason. Then that assistant will step in and take over her defense, which is ludicrous because totally not prepared to do such things. It'd be like me grabbing the file and then going on the fly. You know, like it's going to be hit and miss, and or she's going to think that this is her reason for appeal, and you know, because she is going to want to come out of the courtroom, the jail every now and then, you know, for stuff. Maybe be the only visitor she ever gets is lawyers or cops or prosecution. But I think, yeah, she's got an ace in the hole, all right. I think she's going to try and pull something. She's going to try and pull something in that courtroom. That's her ace in the hole. That's what I think. She is going to try and pull something. And if it's not an escape, it's going to be, I can see her trying to lunge at Landon or Al. I can see it. I can see it happening. Like I've had nightmares about it. That's what I was saying, Lisa. It's like, is this her way of thinking, okay, if I'm my lawyer, I'm not sitting in the prisoner's box, I'm sitting at the table and I've got all this equipment around me, and what can I do with it? Like I see all these scenarios going through her mind. Can she escape better? Okay, instead of locking her in a cell, they're going to have to put her in a room where she can have a desk so she can look at all her paperwork. And somebody had also asked me regarding all the discovery, okay, which her lawyers have. Well, her previous lawyers. Her previous lawyers, now this I think is straight across the board. I know in Canada, and I'm pretty sure it's the same in the US. When you are charged with a heinous crime like this, okay, any crime like this where there are crime scene photos that show the dead body, blood evidence, stuff like that, the defendant is not allowed to see that stuff because they keep that stuff like prized possessions. Okay, there's certain things that the defendant is not allowed to see. Your attorneys are allowed to see it because they got to represent you. They can see it, but they are not allowed to show her certain things. And those certain things are going to be, they may be able to show her the photos in the house, stuff like that. But the pictures that were taken at the crime scene when they found Gannon's body in that suitcase under the bridge in Florida, those photos would not be shown to her. She would not be allowed to have that stuff in her possession. That's like keeping a trophy of what she did. So now they have to give that to her. Now, don't forget, you guys, she's not going to have all this stuff in her cell. This is going to be in a special room for her where she can sit there and she's going to be watched. They won't have a microphone on, but they will have a camera on her at all times, so she can't take evidence like that's in the folders. All the disclosure will be given to her. She'll probably have some kind of electronic device to see stuff electronically, but she's not going to be able to take this stuff into her cell with her. Well, the thing is, Titan, she is entitled to represent herself if she wishes. That's your right, and it's the same as in Canada. You can represent yourself if you want, but you have to follow court etiquette. You have to file your stuff on time. You have to know what you're doing. You know what I mean? Like, and that's why the judge went through all those questionings that he did at this last hearing last week, is to make her aware. Like, look at, you're not trained in this. I can do a lot of stuff in court, civil cases, stuff like that, like bail hearings. I can do stuff like that. But to do a murder trial like this, even with 6 to 7 years of intense schooling for this behind me and in my pocket, I would not attempt it. And I've got a lot of training and worked over 25 years in the criminal field. I would never attempt it. Is she competent to be an attorney? No. But it is your legal right to represent yourself if you want to. And that's why I said this trial is going to go for a long time, you guys, because a lot longer than what's anticipated, because there's going to be a lot of objections from the prosecuting attorney. There's going to be times where the judge is going to stop it and have to get her back on track and give her rules of law. Is going to have to correct her line of questioning. Oh, it's just going to be crazy. Like, I have sat through a murder trial with working for an attorney, a criminal, high-profile attorney. And I'm telling you, even with years and years in school, I just can't fathom it. I can't wrap my head around how somebody thinks. There's a lot of things that you can represent yourself for. Don't get me wrong. Okay? 90% is common sense. Tell the truth. But to represent yourself in a criminal trial of this magnitude, you are loony. Like, narcissism at its finest. She thinks she is better and smarter and can outwit. You're not playing Survivor, dear. You can't outwit, outplay. You're not equipped. I refuse to have a battle of wits with an unarmed person. That's exactly what I would have said to Letitia. I refuse to have a battle of wits with an unarmed person, because she claims that she's smart. And this, well, what you just did just showed how stupid you actually are. And I'm not saying stupid in she's not book smart. She has no clue. None. I'll go to the law library. You go there. And most of the law library in jails are outdated. Manik Corelli says you should not be able to represent yourself. It's your given right. You're very welcome, Shivani. Yeah, there you go. Perfect example. Look how bad Mark Means is doing, and he is actually an attorney. Mind you, he's a civil attorney, which is there's a lot of differences in procedures between civil and criminal, but he still went to law school. He passed the bar. Now, he majored probably in civil, maybe wills, estates, stuff like that. I guarantee you he didn't, well, I can guarantee you 100% he did not major in criminal law. And like my first year of college, you guys, I had to touch on oh my God, I wanted to quit my first year. Your first year, if you want to go to become a lawyer, or, you know, somebody like go on to be a judge or a prosecuting attorney, that's mega years. Okay. I went for 6.5 years, and I'm a paralegal, legal assistant, paralegal. So, and it's like, there's a lot of things I can do, but I wouldn't even attempt to represent somebody in a murder trial that is even pleading guilty, because there's still rights and things that you've got to watch for. Okay. I just wouldn't do it. So, like I said, Mark Means, I think, majored in civil procedures, which would include wills, estates, probates, stuff like that. And civil procedures, person against person, like in civil matters. He's out of his element too, but at least he has a little bit more training than somebody who hasn't taken law at all. But yeah, my first year of law was, I had to hit everything from real estate law to civil, criminal, family. Like, you are nailed with everything, and then you choose your major from there. So Darlene, I went for law, also got sick halfway through to paralegal above and beyond. Yeah, it's a lot of work, you guys, and it doesn't stop when you're last year and you graduate, and I graduated with the highest honors. But you know what? I wouldn't be able to do that today because I've fallen so far behind. Like, I haven't kept up on a lot of stuff. Like, laws are updating all the time, rules are added, case files are added, and I just, with what I've been doing over the last 10 years, I just didn't need to do that updating at the cost that it would have costed me. So yeah, corporate business law, oh my gosh. But you learn everything, right back to the BNA Act, laws in 1712 that you'll never use. You got to still know your stuff. So, I mean, there's a lot of people do drop out even before their first year is ended because of that, because it's areas that you're not interested in, but it's areas that in some way or form usually can benefit you in some way. Like, even if you're going to major in criminal law, knowing a little bit of family, a little bit of corporate, depending on, you can get a criminal case where you got a CEO that killed his vice president. Corporate law comes in to help you there, the stuff that you learn there, because you know the different laws surrounding that and why maybe this could interject in the murder of a CEO killing a vice president, So, I mean, it's not wasted knowledge, but it's knowledge that unless you're majoring in that certain field of law, you may not ever use. So, and like I said, you got to update yearly, and it's, and there's fees for being part of the association. And I don't know how it is in the US, but I know here, to be part of the Upper Canada Law Society, it's expensive. So yeah, a lot of precedent laws are changed and set, and precedent is always going to be precedent. It's always going to be used in some form. Even if a new precedent is set, you do still always use precedents that were set, whether there's a new one set for a specific thing or not. What comes into play with that is, like, look at, this is a precedent they went by all these years, and this is how things should go as per that precedent. But this is new information that we feel that precedent should be upgraded and used more freely now than the old precedent. But they still do very much use precedents once they're set. It's not like just because a new one becomes more used commonly doesn't exclude the old precedents. It all depends on how it correlates with what your case actually is and how that fits into your case, which precedent you use, the new one or the old one. So it's very, I'm telling you guys, it's not easy. So I don't know what she thinks she's doing. Yes, Darlene. And that's why they make you go right back into how our laws were initially set. Like most of our laws today in Canada, well, all of them are from the British North American Act. And there's still laws there that are still used to this day from 100 years ago. But when we're talking about precedent, it never goes away. Precedent never goes away. It may be updated, a new precedent used in lieu of, but that precedent doesn't go away, the old one. It's always still there to be used, depending on how it fits in with your case. Now, ask it. If I was sitting here trying to talk to Letitia about something like this, I don't think she would have a clue what I'm talking about. So, and there's also case law, you know, and there is so much to the legal, and people complain all the time, like the lawyer's fees. If you knew what we actually had to do and what we're held to, you would understand the fees a little bit more. And you mess up once, or you get a bad paralegal working for you that does a major mess up, you can be sued by your client big time. You can be thrown out. You can be thrown out of the bar, depending on the boo-boo that you make. So it's nothing to play with, and she's playing. So she's playing with her own life. The only people that I feel sorry with in this, I don't feel sorry for her at all. If she messes up and I don't care. I really don't. The ones I feel sorry for are Landon, Al, and Lena, and the family that have to be cross-examined by her. Now, because Lena is a minor child, I think she may be, I don't know how that's going to go in the US. In Canada, the legal assistant would have to step in because she's a minor child. The minor child would be in a totally separate room with a screen in front of her. And she would be questioned that way. I don't know how they do it in the States, but I know here in Canada, there's no way that they would let the murderer of her brother question her in open court. She would be, if it was in Canada, she would be in a separate room out of the court with a guardian with her and a child advocate lawyer with her. And she would have a screening in the front of her where she could see out into the courtroom or see the proceedings, see the judge and whatnot, but they can't see her. And she would be questioned that way. And I do not believe that they would let Letitia question her. It would have to be the legal assistant because she is a minor. Yeah, I think so too, Lisa. I think there's going to be a lot of, like, even the jury selection, it's going to be a long, drawn out process, but I don't think we will see the jury selection process, but I think she's going to set her own precedent right there as to how things are going to be dealt with by her in the trial when you see her, how she's going to deal with the jury selection. Libra says they put minor children on the stand, and if cameras are present, they don't show her. In a murder trial where the murderer is representing themselves, I don't think so, Libra. I don't think that. I can see children being put on the stand in certain circumstances when they were witness to something that didn't include one of their parents because she was a stepmother. Yeah, I don't know. I don't know. But I just can't see them doing that. Yes, Lisa. So there's going to be a form of protection for Lena if Lena is put on the stand. There's going to be some form of protection. I do not think that they are going to put her in a courtroom in front of Letitia, with Letitia now taking over her own case. I don't think it's going to happen. Domestic goddess. I'm sure by the time it goes to trial, she will say that she has passed the bar and is now an attorney, along with being a doctor, along with being a teacher. Yeah. Yeah. Shivani, yes. Like, especially even if Alana is in a separate room, like I said, she will have a guardian with her, which is a family, mother, father, friend, whatever. Some kind of parental guardian, and I believe a child appointed lawyer will also be with her. And I believe that there will be a screening of some kind in front of her so she can't be seen. And I do not think that they're going to let Letitia cross-examine her. I believe that they're going to be asking for a special attorney that Letitia is going to, once Lena is questioned by the prosecution, brought as a prosecution witness, once the prosecution is done, I believe that they will take a break and Letitia will have to write out what questions she wants asked of Lena, and I believe it's going to be done by somebody else, a special attorney or something. Yes, being a witness to your mom's murder, I mean, it's not the same. This woman was her stepmother, and her stepmother killed her brother. Her stepmother might have also been abusive to her. This is why I'm saying I do not see it happening. Right. I get that, Libra. The perpetrator was not representing himself. And it was the perpetrator one of that child that was on the stand's parent? I don't think so. Well, it's going to be interesting to see. It's really going to be interesting to see. Yes, Lisa, that is what I just said. Children have their own attorney in Canada who advocate for them. Yes, that's what I had just said. She would be in another room with a guardian and a child appointed attorney. That's how it is in Canada. Yeah, we're going to have to wait and see, you guys. Like I said, I know how the rules here in Canada work, but I have no idea. I mean, I can just, this whole thing now has been turned upside down and everybody's scrambling, like, what the hell, you know? And not like, Alan should be really more at ease now. You know what I mean? He's still going to prosecute it the same way he intended on, but I can just see him like, oh my God, can I get a voice recording of myself saying, I object, I object, I object, because I'm sure he's going to be saying it at least 500 times a day. So he should get, you know, one of those buttons, those easy buttons for Staples, easy button. He needs a button where he can say, I object, instead of having to say it every time, because I think it's going to come out of his mouth quite often, because she has no idea about the etiquette and how to pose questions and what is allowed and what isn't allowed. And it's not a blanket rule of what can be said, what can't be said, and how it can be said and how it can't be said. You can ask something that the prosecution objects to, and if you know what you're doing, you can think about how to ask that question in a different way that fits within the rule. There's rules. So I can see, I object, I object, I object, I object, like taking up most of the court's time. Whereas attorneys know that a question they want answered can't be asked. Goes against the rule, but they can ask it in a different way that fits within the rule. So it's like she has no clue. Objection buzzer. I object. I object. Can you imagine? Rob would get some throat lozenges and everything and have a nice cup of honey tea sitting by you because you're going to be saying I object a lot. I said he needs one of them buttons. I object. Objection. And then one for the judge, it says sustained. Oh, it's just going to be a shit show. But anyway, you guys, that's what I got. I've been here for about an hour and a half, taking up your time. I want to thank you guys all for coming out and seeing this new stuff that was filed. I have been checking on the Letitia court filings page, and I haven't seen nothing. Nothing filed since she's... So maybe something will be filed after tomorrow's hearing, but I see nothing been filed since she had become her own attorney. And then there will be filings from her attorneys now to be removed from the case. So anyway, we're going to see what happens tomorrow, you guys. Please, 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 if you do go into the courtroom, mute your mic, turn your camera off, and don't touch any buttons like I did. I was trying to, somebody was telling me that you guys weren't hearing it. And I thought I was messing with my StreamYard, but I wasn't. I was messing with the actual WebEx buttons. Oh, and we all know what happened there. So I will be watching that tomorrow, you guys, and we'll probably do an update. It is at 8:30 a.m. Colorado time, 10:30 a.m. Eastern. So yeah, maybe in the afternoon, I will go over everything that I got from that hearing to let you guys know that haven't been able to make it into the courtroom. I will go over everything that's said and done. I cannot stream it. I cannot record it. I'm not going to attempt it at all. Zero chance of that. It's against the law in Colorado. Idaho, they let you do pretty much whatever you want, except for talk and jump into it, but they let you stream it. So, okay, so I will see you guys again tomorrow afternoon, where I will have the updates on the Letitia Stout hearing that is happening. It's a case conference. Okay, great. That's good to know. Libra just said children have an attorney here in the U.S. that advocate for them as well. Perfect. Okay, so again, Darlene, prayers going out for your son. I don't think he needs them. I think he's going to kick butt on that, and he's going to do fine. And we are going to all be anxious for the link from you for that once it's done. And we will all give our congratulations to him. Okay, so until tomorrow afternoon, you guys, please stay safe. Please take care of yourselves. And again, if you go into the courtroom, please mute your mic. Stop your camera. Don't say nothing. Don't touch none of the WebEx stuff. You're going to get in trouble and get booted like I did. Okay? So I'll see you guys all tomorrow. Thank you for joining me for this hour and a half this afternoon. And I hope the information was useful to you. And give me a thumbs up there if you haven't already on your way out. Okay? Merci beaucoup, Giovanni. Adame. Okay. I'll see you guys all tomorrow. Bonsoir.